Good evening. Like Linda said, my name is Bob Menges, and here tonight, Linda invited me a couple of months ago, and I really appreciated that to come and speak to you. And primarily, for probably the last 15, I'm just going to give you a little bit of my background so you know where I'm coming from. I'm here tonight to speak to you primarily about the United States Constitution. Linda told me that, Bob, most of our folks would probably have been in Myrtle Beach, so don't repeat the same thing. Well, I wasn't planning on doing that, but I like the fact that you gave me extra time. So Linda's giving me about 45 minutes. So that's what I'm going to roll with. Normally, what I've been doing for the last 15 years is speaking and teaching on the United States Constitution as the rule of law. My wife and I started homeschooling our kids about 16 years ago. 3 daughters, and 2 of them graduated from high school, have now graduated from college. The youngest daughter is a senior in high school, so we're at the end of our journey in our homeschooling enterprise, if you will. But where I got started was I've always been a big, somebody, one of these political geeks like we all are in this room, and big history buff. And so one of the things that homeschools do is they do co-ops. They get people to teach different subjects, especially for the high school years. So I picked up a course on constitutional law about a little over 14 years ago, and muddled my way through it. And but anyways, decided to start teaching high school kids, 10th, 11th, and 12th graders. So 15 years later, that's what I'm doing. I do it every year because I'm extremely passionate about the fact that we are, one of the things that you're going to see me put up a slide tonight. I'm going to teach you about a guy. How many of you were in Myrtle Beach? I don't want to repeat myself. Okay, some of you weren't there. So those who were there, bear with me. You might hear some of the same stuff again. But I'm going to go down a little bit in the weeds on the Constitution for you. And if for those of you that are intimate already with the Constitution, please forgive me. I don't want to be insulting your intelligence, but I want to teach it at its basic level for the time that I have. So I plan tonight to teach on the United States Constitution, and in my new role from September, I took on the role as the state director for an organization called the Convention of States Project. So I'm here to speak to you about that towards the end tonight and go into that a little bit. But primarily, I just love teaching the Constitution. And I have to relate this story to you because it is the providential hand of God. Now, those of you who are here tonight, if you're not believers, if you're not Christians, you got to forgive me because everything I teach has to be taught from a biblical worldview, because I believe that our faith has to impinge upon everything that we do. So I'm not apologizing for that. I just want you to know that so that you know where I'm coming from. But with that said, probably about 8 years ago, in one of those classes, I teach this course to high school kids every Thursday night for, like I said, the last 14 years, for the whole school year. We start in September and we go till May, first week in May. But every Thursday night we meet for an hour and a half. About 8 years ago, and I meet in a classroom at my church, Northwood Baptist Church. About 8 years ago, I was teaching, probably about the middle of the course, I was teaching on the Establishment Clause and the erroneous way that the Establishment Clause is looked at today. The First Amendment, Congress can make no law establishing religion nor prohibiting the free exercise thereof. So, teaching that, and at that time, if you remember, some of you that have lived in the area a long time, you know that President Senator Tim Scott was a county councilman at the time. Some of you may recall he put the 10 Commandments up in Charleston County Chambers right about the time, a little bit after Roy Moore had done that with the big monument. And long story short, he kept it up. Eventually the ACLU was screaming, the rest of the county council, they voted to take it down. Long story short. So I was trying to use real life examples. I was teaching on the Establishment Clause that night, and I was making I chose an example. Now, I had never met Tim before. That was about 8 years ago. I knew he was an all-state guy, and I knew that he was on county council. But I used that as an example that night. That particular night, I was explaining how 10 Commandments were up on the wall. Today, the Constitution has been so perverted and so stretched, this whole notion of separation of church and state and all of that. And the reason the county council took it down is because they're afraid of a lawsuit, because the courts erroneously interpret the Establishment Clause to prohibit anything remotely religious. So I'm talking about that, and I'm telling them about the guy that was the Charleston County councilman. And I'm usually meeting in the social hall at our church, and on the back door. This is a true story. I go to the back door, and I said, class, hold on. I go to the back door, I open it up, and I'm facing this bald black man, Tim Scott. And he looks at me, I'm perplexed, and he says, well, I'm here for a homeowners association meeting. He lives right down the street from my church in Northwood Estates. And I'm here for a homeowners association meeting. Well, the homeowners association Northwood Estates uses our social hall on a Thursday night, and I know the schedule because I have to move out that night, my class. So he goes, I'm here for the homeowners association. I said, no, Bob Menges, hi, I recognize you, Tim Scott. He goes, I said, you got the wrong night. That's next Thursday night. And he goes, oh, I'm so sorry, and he apologized. I said, well, hold on. I said, I was just talking about you. And he looks at me like, you're crazy? And I said, no, I'm talking about teaching a con law course, and I'm telling these kids about the plaque that you put up. And he's got this look on his face like he can't believe it. And so I said, well, since you're here, would you mind coming in and talking to the students? So he comes in, he talks to them, we do the whole bit, we meet, we met that night. Every student in my class, some students to this day think I set that up. It was a providential meeting, providential hand of God brought us together. At that point, we became friends. My daughter was a student in that class that night. My oldest daughter was a student in that class that night. On the way home, she kept telling me, okay, Dad, I know you didn't tell those students that, but you set that up, right? I said, I did not set that up. And so, long story short, we became friends, and in 2010, when he decided to run for Congress, he was a state house member, he asked me if I would mentor him or tutor him on the Constitution. So we met at a Barnes & Noble every Saturday morning for about an hour and a half. And this kind of guy he is. Tim's not perfect. Him and I have butted heads since he's been in office. We're great friends, but human beings differ sometimes, right? Sometimes we have differences of opinion, but good people can agree. Or agree to disagree. But anyways, that's the kind of guy. He's a humble guy. A lot of people would never, are running for federal elected office. I'm not going to let anybody know I need to tutor on the Constitution. But he knew I'd been teaching it for years. So anyways, we did that. And we did it for about 3 months. And but anyways, so from there, I've been teaching for like last 14 years, but I've started speaking and going into the churches. My pastor asked me if I would develop because my passion, I teach a course on biblical worldview in my church. And folks knew that I taught the Constitution, so a lot of people were saying, well, Bob, when are you going to do something for us on the Constitution? So I put together a 12-week course, and this is a sales pitch to you. Sales, not in sales, I'm not selling anything. I do it for free. If any of you members of your churches would like me to come do that, I'll do that on Sunday nights for free. I'm not going to charge you anything. That's my passion, to teach the Constitution and the biblical worldview of government. So there's my pitch. My card's over there. If you go to look at my website, the course is on the website. You can watch it for free. There's nothing for sale on there. I just want people to learn the Constitution. So with that said, I'm going to talk to you tonight about the United States Constitution and the rule of law. So I'm going to be hollering advance since we're doing this on the fly here tonight, because I don't have my computer or I don't have a clicker. So bear with me if you see me going like that and nothing's happening. But this whole idea right here that the Constitution is the rule of law, it's a huge concept, it's a huge understanding to get down as our baseline. If we call ourselves constitutionalists, we need to understand a little bit about the history behind it, actually a lot about the history behind it. But there's nothing that really appalls me more than this, and I don't mean this in a bad way, is that folks that will wave around a pocket constitution but not take the time to read it. Now, we're not all called to be experts, and that's a stretch for me. I certainly don't know it all. You could stump me on things, I'll tell you right now. But I have been studying it, writing about it, and looking at it hard for about 15 years. So I have some expertise on it, and everybody's not called to do that. But if you're a constitutionalist and you're engaged in our country today, it is imperative on you to look at it, to read it, to at least know the basic breakdown. So that's what I'm going to do tonight. I'm going to do a basic breakdown of the major areas, and then I'm going to dive into I'm going to go down deep in a few areas, because again, that's 12 weeks and I'm just going to try to skim the surface and then dive in a couple of places that I think are important tonight. But if you go to the next slide, I can't teach the Constitution and not look at this right here. Romans chapter 13. For those of you that are believers here tonight, that claim Christ, one of the things that we see in the book of Romans chapter 13, it says, go backwards, please.
Backwards?
Yep. Back, right there. Nope, right there. Every person is to be in subjection to the governing authorities. I am convinced, and again, you can disagree with me, but I'm convinced that for too long the church has misunderstood this passage right here. Now, Bob, who are you to say that? You're not clergy. I've studied this for a long time, and when I get done, I think you'll see my point. The governing authorities in our country, there is a particular application to Romans 13 in the United States of America. And the reason is because we're to be in subjection to the governing authorities. And when I teach this to high school students or adults alike, I always ask the group, who is the governing authorities in our country? And people will say, well, it's the president. Some people will say it's the Congress. Every once in a while, somebody will say it's the judiciary, although that doesn't make any sense to me at all. But they point to people. And one of the things I want to point out is that in our country, it's not a person. It's the United States Constitution. Now, hear me right. Nobody leave here tonight saying Bob's preaching, teaching or saying that we shouldn't be in subjection to those that are placed in authority. I work for a boss. He's an authority over me. If you're working today, then you have an authority over you. We have authorities over us in different realms. But the ultimate governing authority in the United States of America is the United States Constitution. Ask anybody that takes oath to federal elected office. They're taking an oath to the United States Constitution. And one of our problems is that we have those that are blatantly disobeying their oath. Okay, so next slide, please. The United States Constitution, you notice I had the rule of laws because I want to emphasize that you would leave here tonight with the idea that the United States Constitution is the rule of law. And that phrase simply means that it is the baseline. It is the law. It is the highest law in our land. And I have another word up there. It says Lex Rex. How many of you are familiar with the word Lex Rex? Lex Rex was a book written by a guy named Samuel Rutherford during the Protestant Reformation. And it's Latin for law is king. Now, you'd say, well, Bob, what's the big deal? Move on. But you have to remember, back in that time frame, it was the opposite. It was Rex Lex. King was law. This was a radical concept that came out of the Protestant Reformation. A very radical concept. And I would submit to you, and I've read the founders intensely and in depth, read a lot of the founders, that their guiding principle, their guiding underlying principle was this understanding that king couldn't be law. There had to be a law higher than men. Now, if you're a believer in here tonight, I would submit to you that the highest law is God's law.
Amen.
But we're not in a theocracy in our country. Our founders understood that people could come to Christ. The only way people could come to the Lord would be when God draws them, when God moves in their hearts. They understood that you couldn't force people to be Christians. So they wanted liberty. They wanted to create a system of liberty where that could flourish and people could do that. And God could work among his people and in the hearts of people's lives. So they understood that principle. It's a bedrock principle of our Constitution. If you want to understand our Constitution, you have to understand the rule of law and the idea that law is king. Never forget that. All right, next slide, please. So why does it seem like our system is broken? If you pick up the back of my own card, there's got cards over there for the Convention of States that I'm volunteering with. I'm not paid, I'm volunteer. And then my own cards that I've had for years. Again, if this is something that I do, whether or not I was working or volunteering with the Convention of States, I will continue to work teaching the Constitution. But a little-known guy by the name of George Nicholas, and those of you in Myrtle Beach, bear with me, you heard this already. Probably at light warp speed, though, because I was flying there. In Richmond, Virginia in 1788, this was the time that the Virginia House of Burgesses, or the General Assembly, was looking at the Constitution to ratify the Constitution. And in that ratification convention in Virginia, there was rancorous debate. I mean, heated debate, and very heated debate. Heated to debate to the point so much that there was almost a duel between Patrick Henry and Edmund Randolph. And between the Federalists, if you will, and the Anti-Federalists. Federalists, just a quick reminder, were those people that, again, they were meeting to modify or to amend the Articles of Confederation. And there was great debate and heated discussion about how much power to insert into a central government. Federalists were those that believed that there needed to be a certain amount of power seeded up into a central government. The Anti-Federalists were also understood the need for a stronger government than under the Articles, but they were extremely leery of it. Today we would almost say they were prophetic, right? But anyway, so this guy, George Nicholas, hardly anybody knows him today, but when in my studies I came across this guy, and it just, I'll never forget it. Stands out to me. The quote's on the back of my business card. I urge you to take one, stick it in your pocket, and just whip that out sometimes on people and learn that quote. But he said, an enlightened citizenry will never suffer. It's an 18th century term for let happen. What was established for their security to be perverted to an act of tyranny. What was established for their security, that was the United States Constitution. So he stands up in the midst of this war between the Federalists and the Anti-Federalists. He says, everybody calm down. I doubt he said that, but that was his intent, you know. He was known as a pretty rotund fellow. Madison kind of made some jokes about his weight. But anyways, nevertheless, I think what he said was extremely profound because he said an enlightened people, now that's a term we don't use much today, but what he meant was a knowledgeable people on the Constitution will never let it be perverted to an act of tyranny. So you don't have anything to worry about. Those of you that are worried about it, no problem. And enlightened people will never let that happen. And I will be teaching something about the Constitution and about the way that the limited government is supposed to work under the rule of law. And I'll explain to them what's happening today, and they'll look at me and they'll go, well, Mr. Menges, if what you're telling us is true, as if I'm lying to them, but they don't mean that. But they say, if what you're saying is true, I've had several do this, then why are they doing that? And the answer is George Nicholas. Why do they do that? Because we let them do it. We're an unenlightened citizenry. You guys are the exception. You're here tonight because you want to learn. You're participating in CIA. You're either part of CIA, 9/12, Tea Party, whatever. Constitutional conservatives, you want to be involved. But the vast majority of our citizenry they're not taught this. Our public schools aren't doing this. One of the reasons I've been homeschooling, I'm not here to bash the public schools tonight. You can see what's going on with Common Core. You know, Common Core is a lot of people think it's a new thing. Common Core's been around for years. That's why I homeschooled my kids. It just has a new name today, but the indoctrination has been there for many, many, many years. It's just that it's taken to a much higher level at an accelerated pace. But I just think this is incredibly profound right here, and enlightened people will never let that happen. It's so important for you to be, and we probably wouldn't use the word enlightened, but understanding of the basics of the United States Constitution. Because here's the other thing, not only if we don't understand it, how do we elect people that understand it? Nobody can ever answer that question for me. You guys can. But when I'm having general conversation with people, if we don't understand, how can we do that? We don't know it. And then when we elect them, how do we know when they're abusing it? Because we don't understand separation of powers. And I'm talking about the actual the actual checks that are in there built in for these people to use. They don't, well, I'm not going to go into that. I'll talk to you later about that. There's a bill that Tom Rice is pushing through right now. I mean, it's well-intentioned, but there's a constitutional check for what he's trying to do with the particular bill. And I had a long discussion with him in Myrtle Beach about it. I mean, I think it's well-intentioned, but it's like, there's a check right there. Why don't you use it?
Well, let me ask you. Would you
can we hold off on questions till the end? Because if I do questions, I'll never get through. And I got a lot I want to cover. I promise you at the end, you can bombard me. You can tear me up with questions.
Delusions. It's just the delusions of this security.
Right. But we elect people like that, and then that's why it's crucial for us to understand these things. So next slide, please. I got to move along. Jefferson said the price of freedom is eternal vigilance. And perfect example is, how many of you are familiar with S308? S308, the restaurant carry bill. The restaurant carry bill was my bill. I authored that bill. I authored that bill 3 years ago. Senator Mike Rose, who's in here in the room tonight, introduced that bill for me because he understands that we've had a lost liberty right there. And a certain particular senator in the Senate by the name of Jake Knotts literally sat on the bill and it could go nowhere. So long story short, I had it reintroduced again in 2013 and worked like the Dickens on the outside to push it through. And a lot of good people, certainly not just me, but we organized the troops and pushed it through. We got it through. My point is this. That's just a little thing. A little thing. Restaurant carry is such a little thing, but it was extremely difficult to get through the General Assembly. I mean hard. And I'm talking about just a little fix. And here's the point here is this, is that that's a little piece of our liberty that was lost a long time ago. To get it back, it's like pulling teeth. Jefferson said, you better guard it because when it goes, you can't get it. It's easy to lose, but it's tough to get it back. Very hard to get it back. These guys knew that when they said that. Next slide, please. Relationship between liberty and order. Real quickly, what did the 13 states actually do at the Philadelphia Convention? Some people call it the Great Convention. Today, a lot of people call it the Constitutional Convention. Negative. That's wrong historically. The word Constitutional Convention did not come about until later on. It's a modern term. These people call it the Philadelphia Convention. They had just come out of the Annapolis Convention the year prior to that. But the states created the federal government. Never forget that. If you're a constitutionalist, the states created the federal government. It's a creature of the states. It's a child of the states, if you will. They seeded up a limited set of powers. The best way, one of my illustrations, and maybe you have a better illustration, but mine is that there's this bucket of powers. Okay? And the founders, when they were creating or trying to meet the exigencies of the Union, that's what they were charged to do when they went into convention, to fix the articles or to make the articles stronger, because the colony, the states were going to fall apart under that. They would have easily been defeated because they were warring with each other economically. So here's this bucket of powers. So picture the framers, 55 attendees to the convention, 39 signed it. Picture them picking powers out of a bucket and seeding them up into the federal government. This power they need the power to regulate commerce among the states. We're going to talk about that a little bit more in a minute. Because the states are warring economically. And there's no referee to mediate that. So the founders and the framers said that power needs to go to the central government. And this one here, and that, no, not that one, we're not giving that one to them. That one there, and all the rest of those, no more. That's all. They ceded up a limited handful of powers to the federal government. They carved out a subset, if you would, of agreed upon powers. Very, very small. Think about this. The manual for our United States government can fit in your pocket. Those little pocket constitutions. That's the manual for our government. That's all there is to it. I mean, we look at the behemoth Leviathan today, right? I mean, it's huge. You know, the federal government is designed to be the size of a pea, with just certain enumerated powers to be able to referee these states. That's it. And it's grown to ridiculous proportions because of an unenlightened citizenry has done this. He said an enlightened citizen, we hear an unenlightened citizenry. So next slide, please. Madison said every word of the Constitution ultimately decides a question between power and liberty. Every single word ultimately decides a question between power and liberty. Now, just real briefly, we all understand, reasonable people understand that we have to give up some of our liberties to create order. One of the institutions that's ordained in the scriptures is government. Government is an ordained institution. The family first, the church, government. There has to be some order, otherwise there's anarchy, because the founders understood this intently. The founders understood what was called the biblical doctrine of the depravity of man. They knew what man was capable of. They'd seen it down through history. People argue all the time with the founders, well, they weren't Christians. These guys were deists. You know, and I've studied them, and I've come to the conclusion, and I don't know what's in any man's heart. Even if I was able to transport back to that time period, because I love to study the colonial and revolutionary war. I wish there was a time machine. I would go back, but only if I could take my AR-15 with me. And I have a couple of those. I would take them with me. And a lot of ammo. But anyways, they understood that there had to be this check upon man's sinful nature. And so I tell people this. They can argue till the cows come home about this guy was a deist, this guy's one. I've studied it. I'm convinced vast majority more Bible-believing Christians. But even if I'm wrong, I will tell those that argue that, forget it. That's a smokescreen. The vast majority of those framers had more of a biblical worldview. They looked at things through the lens of the scriptures because they were washed in that. You know, people can read the Bible all day long and not be a believer. There's something that has to take place in the human heart, regeneration for someone to be a believer. But the vast majority of them, I would submit, have more of a biblical worldview than most Christians do today. But that's another subject for another time in a sermon. But I would submit to you that that is the truth. I told you I teach a course on biblical worldview because I think most of us Christians, we're so conformed to the way the world does things, we don't really think biblically about things. And there is a biblical way to think about everything. The Bible either speaks specifically or principally about every issue of life, even government. Next one, please. So also, the United States Constitution, also known as the Federal Constitution, has 7 articles and 27 current amendments. First 10, I'm sure you all know, are the Bill of Rights. Next slide. So this is just a little breakdown. If you look at it in comparison to the Declaration of Independence, the reason I keep looking at my watch because I'm trying to gauge my time is so I can do a little presentation on the Convention of States for you. But the Declaration of Independence, approximately 1,400 words. The United States Constitution, about 4,500 words. Well, this is kind of academic. Why are you going into that? There's a reason why. Again, 4 parchments. You go to the National Archives, you'll see there are 4 parchments that make up. They're about this big, animal skins, if you will. And 1 parchment for the Declaration. Next slide. There is a relationship between the two. There really is. Do you know that the Declaration of Independence is the charter for our nation? Most of you know that. It's the founding document. The United States Constitution and its forerunner, the Articles of Confederation, were a set of bylaws, a set of governing rules, if you will. If you were to start a corporation or a business, you would need to have a charter, and then you'd need some kind of governing bylaws, because there's going to be humans in there, and you have to regulate it somehow. There's got to be rules on how the game is played. The Declaration of Independence, for the most part today, people look at it as a national ornament. It's not a national ornament. It is a legal document. And it's crucial for constitutionalists to understand this, because if you want to understand the Constitution, you have to understand the Declaration. The Declaration sets down the major principles. Matter of fact, they said for these reasons, governments are instituted among men. People all say, well, what's the purpose of government? Everybody has their own opinion. We don't have to wonder about that as Americans. In our founding charter, it tells us the purpose of government is to do what? Protect life, liberty, and the pursuit of happiness. And by the way, the pursuit of happiness in the 18th century, in the colonial area, wasn't hedonistic happiness, that I want a Maserati, I want this, I want that. It was the idea of pursuing my God-given talents. It literally means property. That's what it means. Protection of property. But the Constitution develops that charter. If you want to understand that, people always say, well, the Constitution doesn't have anything religious in it. They didn't feel like they needed to put anything in there like that, although I would argue with that point too. And I had a debate many years ago with our resident atheist down at the College of Charleston, Herb Silverman, about this. But the Declaration, they clearly said what they said in there. They said what our country was founded upon, and they built the rules upon those principles. Would you go on and just hit the down arrow a couple times just to bring up the arrows for me, please? So just a real quick breakdown right here. As a constitutional conservative, and again, please forgive me if I'm telling you stuff that's basic and you already know this, but I want to make sure we all get the basic understanding here. The first 3 articles you should have committed to memory. As a constitutional conservative, they ought to be committed to memory. My students have to have them in the second week of class. They have to have those 3. Article 1, the legislative branch. Article 2, the executive branch. Article 3, the judicial branch. Separation of power. I mean, you listen to the president the other day. I've got a pen and I have a... That should have made us all recoil, and I'm sure among us it did. But the vast majority of our nation just went on and yawned. It was an abhorrent statement to make. It was repugnant to our constitutional separation of power. That one man thinks that he can assume, and I'm not going to beat up on just him because we've had presidents before him that did it too. We've just never seen it at this pace, this torrid pace. But where one branch says, if you don't do it, I'm going to take your power. And here's what's worse than him doing that. That's abhorrent to hear him say that, right? You know what's more important to me? To hear silence from the United States Congress. Yeah. Except from a few. Except from a handful of a few. Yeah. Article 1, Article 2, Article 3, and then the 4, 5, and 6, the relationship between the states and the process for making amendments, Article 5. Article 6 says the Constitution is the supreme law of the land, and then the last part right there, you have the signatures on it. But really important to Article 1, Article 2, Article 3, think in terms of the Article 1 branch, the Article 2 branch, and the Article 3 branch. Well, why, Bob, what's so important about making that distinction? It's extremely important because you need to have command of this document. As a constitutional conservative, you need to have some command of this document. Speak like a constitutionalist. Okay, next slide. First 52 words, the preamble, 6 core purposes which the Constitution was written. It defines and limits the remaining 4,450 words. Go ahead and hit the next down arrow. If I had time and I had speakers, I would play for you. Just my students get a kick out of it. Does anybody remember Barney Fife doing the preamble? It's classic, and I usually always play Barney Fife reciting the preamble. He doesn't know a single word of it, but when he's done, he knew it all. But anyways, you're all familiar with this, the preamble. We, the people of the United States, in order to form basically 6 things that they said this is what the purpose of this manual is for, is to do these things right here. To form a more perfect union. Why? Because, again, you've got to think historically. The Articles were a failure to some extent. That may be a little bit of a harsh word, but there were problems with the Articles. Good people can disagree on that. To establish justice. To ensure domestic tranquility. To provide for common defense. One of the primary functions of the document. To promote the general welfare, one of the most abused portions of text in this document. I plan to dive on that a little bit. To secure the blessings of liberty to ourselves and to our posterity. Interesting statement right there for those of us that are pro-life. Who's our posterity? It's not the people that are living now. Okay, next slide, please. Just some real quick facts. Just go through them real quick. Adopted by a convention of 12 states, September 17, 1787. Ratification by 9 states completed in June of 88. And then the first Congress begins in March of 89. So we're now, and that's the way Congresses are numbered. They're numbered in the shortest term of service. United States Congressmen, House of Representatives, 2-year terms, as you know. So every 2 years we have a turnover in Congress. Some of us wish there'd be a bigger turnover in Congress, but it turns over somewhat. It's supposed to. We're in the 103rd. We're in the second year of the 113th. Therefore, we have an election coming up this year. So in January 1st of next year, it will begin the 114th Congress. So the first, under the new government, the first element that stood up was the Congress, if you will, stood up and took its role. Washington was inaugurated in 1789. In April, the election was actually held from December to January of January 88 to 89. He was inaugurated in April, so March the Congress stands up, April the President stands up, and then the first Supreme Court sessions begin in February, a couple years later, a year and a half so later in 1790. All right, next slide. Again, the 3 branches right here, the legislative branch, the executive branch, the judicial branch. Those of you that are fans of Law Builders and David Barton, you've probably heard this before, but it's always interesting to me. Isaiah 33:22 says that the Lord is our judge, the Lord is our lawgiver, the Lord is our king. Look at where the principles for our government came from. Separating power. Some people say, oh, Bob, that was just a coincidence. It's a big stretch. Maybe I'm wrong, I don't know. But they could have chose 4 branches, or they could have chose 2 branches. They chose 3 branches, and they separated them into a lawmaking body, a headship body, if you will, an executive, that had a very limited role, and a lawmaking and a judging branch, the judiciary. All right, next slide. So this is, there's a lot of things I have. When I teach this over 12 weeks, I have a bunch of these slides that go through all the nuances of the Constitution. I can't do that tonight, but this is huge. The first principle of American government comes from the very first sentence after the preamble in the Constitution. The first principle of American government is only legislators can make law. It's a clear separation of power. Mm-hmm. Only legislators. It says that all legislative powers herein granted will be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. They split it up into a bicameral body. But this is huge. When people say, it really could get us into discussions that we don't have time for on the whole idea of executive orders. Are executive orders constitutional? Only if they pertain to powers that have been enumerated to the Article 2 branch. There are certain things that have been enumerated as powers to the president. He has the power, again, constitutionally, not what they're doing today. Again, now I'm telling, this is perfect world. This is the United States Constitution. We have to understand that before we can see the deltas, the differences from where we are today. But he can sign an executive order for something that he has a power already vested for. He cannot sign an executive order for something he has no Article 2 power. When I say that, I mean I'm talking about the things that the founders gave the Article 2 branch, the powers that were given to it. Next slide. Enumerated powers, go on one more time. This is Article 1, Section 8. Look right here. See this right? Do you notice the indentation right here? You see that? A guy by the name of Jacob Shallis actually took quill to animal skin. And he documented this thing. You think he just indented that because he felt like indenting? No, when you study the Constitution and you study the Federalist Papers, this is an introductory clause to Article 1, Section 8 right here. And then there are indentions. Matter of fact, I'm convinced that Jacob Shallis had Microsoft Office or Word. You know those little bullets that you put when you do a document? I'm a tech writer, so I get all that stuff. He would have used bullets. He would have indented with bullets, but he didn't have Microsoft Office. They're probably thankful they didn't have Bill Gates. So hit it one more time. I'm going to zoom in and show you. Look at this now. Here's a zoom in. Look at it right there. Bob, what are you making such a big deal about that this guy indented these things right there? There's a reason why. Does everybody see that before I move on? Mm-hmm. I want you to have a really good picture of that in your head. All right, next slide. Okay. Congress shall have the power to lay and collect taxes. So Article 1, Section 8 is where the powers are enumerated or vested into the Congress to do that stuff there. To lay, to levy, to call for taxation, and to take it from you. Always remember that all taxes are confiscatory. It means they're being confiscated. Now, obviously, I think all reasonable people would agree that we have to pay taxes for something. right? But never forget that they're all confiscatory. They're confiscated from you. But the founders put in here, the framers said, okay, here's what, and they listed the powers. And I can't go through each one of them for the sake of time, but there are 18 of those. Some people would say 17. I think 17. I think this is an introductory clause. If you count this one, you would have 18 enumerated powers. But notice it says, provide for the common defense and general welfare of the United States. Next slide. Next one. Well, go back one. All right, right there. Let me go ahead and hit on that. One, go down one.
That one?
Yeah. All right, right there. I'm going to highlight the general welfare because what will happen is today this is one of the most abused, it's one of the two most abused portions of text in the Constitution. It's one of the most, if we were to have and I'm going to talk about a convention of states, if we were to have a convention of states, one of the things that would probably, again, nobody's going to listen to me probably, but if somebody asked me, I would say that this clause needs to be tightened because I know the intent, I know the original intent of this, and you can too if you study it. In other words, it's not hard. We can determine original intent. I plan to speak a little bit on original intent in a moment. But we can determine that for the most part. I can go to the Federalist page, I can go to Federalist 41. James Madison explicitly explained what was meant in that introductory clause. Because there were people that were raising the issue, even back then, they were worried about the language right there. Some people say, well, the language is good, we just stick with it. Well, nobody's a bigger constitutionalist than here than me. I love it. I spent 20 years in the Air Force defending it. I spent the last 15 years defending it by teaching it. But this right here, the General Welfare Clause, is the most abused and twisted and perverted piece of text in there because I don't have to explain to you why. Think of the words general welfare. So in other words, there's a catch-all today. If you can't find out where it's at, even Nancy Pelosi doesn't even know that one. There's a YouTube out there, you can go pull it up. During the health care debate in 2009, there was a reporter who had the audacity, not very many reporters today, had the audacity to walk up to her, and the cameras were on her in the rotunda, and he said, Speaker Pelosi, can you tell us where in the Constitution you have the authority to legislate health care? Go look it up. I can't even do it justice what she did, but it ought to make you could use it for Ipecac. If you watch it. You could if you ever have to vomit. She says, she laughs, she goes, ha, ha, ha. Authority, she goes, we just do it. That's what she said. I'm not making that up, that's what she said. She didn't even cite that. Today a lot of them will just go, general welfare. It's a catch-all. The General Welfare Clause was an introductory clause, and Madison tells us in Federalist 41 that this clause regulates the succeeding enumerated powers. Madison goes so far as to say, because there was a debate, some people thought the language was too loose and it would get abused. Those people are prophetic today. They were right. The language turned out to be too loose, but I would suspect it's too loose because of us letting people get elected that don't study this stuff. He said, why would we list the powers? Why would we spell them out? That's what enumerated means. Why would we do that if the preceding clause meant anything and everything? It's just simple logic. But we're electing people today that either don't know that or don't care. And I know my friends from the John Birch Society are here tonight, and I applaud them for the education effort. I stand with them in that. That's our biggest problem today. Is that we have, I'll give you another example. When I was, and back in January, the special election for Tim Scott's seat, I was one of those people who raised my hand. I'm so sick and tired of electing people that don't know this stuff. I'm going to run. So I raised my hand and I said I'm going to run. And I got some counsel from some people. I remember picking Mike's brain, asking him, getting some ideas and stuff. And anyways, long story short, you know that originally like 24 people originally going around, which is ridiculous. And then there was down to 16. Long story short, I teamed with my friend Curtis Boss because him and I have been friends for years. Dear friend of mine. And my wife and I decided it wasn't time for me. And time wasn't right. And we didn't do it. But before I backed out, there was a local radio talk show host. I won't call his name because he's a nice guy. But he had me on his program. He said, Bob, tell us about yourself. Nobody around here knows who you are. So I'm on there and I'm talking Constitution. That's what I do. I'm telling about Constitution. I'm not trying to boast. I'm just saying that's me. And after about, I don't know, not even 30 seconds of that, he goes, oh, enough of the Constitution, Bob. He says, they can just pick up a pamphlet. Tell us other things about yourself. And I said, listen, you're going to elect a guy and pay him $174,000 a year, and you don't care that he's haven't mastered that document? That's the people we continue to elect people like that. And you wouldn't hire a guy to go build a bridge. That he's got to go look up and learn how to do the engineering when he's building the bridge. But we do that all the time with people we elect to Congress. So, next one. And then the second most abused clause right there was the Commerce Clause, just totally twisted and perverted today. The Commerce Clause, in effect, was because the colonies were warring, the states were warring among themselves. It was intended to let the federal government be a referee for commerce between the states. In about the 40s, I teach, in my common law course, we cover about 30 cases, federal Supreme Court cases. And in about the 30s, it started happening where the court started just departing from original intent. They started before that, but when it comes to the Commerce Clause, they really went out there and they came up with what was called a significant effects test. Anytime you hear the word test with the court, you ought to shudder. But they come up with these tests. And the significant effects test is used today as if it significantly affects commerce, then that means the federal government has that enumerated power. What's wrong with the word significant? It's very ambiguous. It can mean whatever you want it to mean. All right, so Article 2, the executive branch, real quickly. Next slide. You already know this stuff. These are some of the powers that the president has. With the advice and consent of the Senate, he can make treaties. The reason I highlighted the advice and consent is because one of my peeves today is that we have a United States Senate that has no idea what its job is. It doesn't. Because of the 17th Amendment, we have senators that don't represent their states, and that's easily provable. Look what happened with Obamacare. You had states that filed federal lawsuit and that their senator was supporting it. How can that be? He's not supporting this. He's not representing the state. And they don't know. Most of those guys today they don't know what their job is. Some of them do. I'm not trying to be mean or haughty or prideful. I'm just telling you that they don't know what their function is. They're all over the map. You probably couldn't get 3 to agree on what their function is. But, and this brings us to this guy. And when he was 2 times for Justice Sotomayor and Justice Kagan, twice Lindsey Graham told us, quote, elections have consequences when it comes to confirmation of Supreme Court or federal judges. Elections have consequences. And I don't know, what does that mean? We all know they have consequences. See, the founders put that advice and consent in there for what I call a rigorous pushback on the other branch. All the checks that are in the Constitution were meant to be used as a pushback against an out-of-control or a rogue branch of government. So it's not supposed to be in other words, in Lindsey Graham's world, as long as the justice is not a criminal, then the president gets to appoint him and he gives them a rubber stamp. That is abhorrent to the framers' intent. The framers intended for these guys, and I wanted to talk about original intent, but I'm running out of time for this segment. The framers intended for their document, and I have some slides, I'll run through them, for the document to be interpreted in the language in which they wrote it. If you were to write a letter today and seal it away and ask your son or daughter to give it to your grandson or great-grandson and pass it down to your posterity, 3 generations down the line, you would want that posterity to read it as you meant it today. Not get it and read it and go, well, I'm just going to read it for whatever I want it to mean today. No. And that's the same way the framers were with this document. Next slide. Oh, back one real quick. One real quick. He shall take care that the laws are faithfully executed. We have a president that stands in front of the country and says, you already know this, I'm going to ignore certain laws and I'm going to use, and then they come up with prosecutorial discretion and all that, which is a cop-out. Okay, next slide. Judicial branch. Establishes the court but does not spell out the specific duties, powers, or organization of the court. The United States Constitution, in its form, its original form, only specifies the Supreme Court. And then it says that Congress has the power to ordain and establish such inferior courts. I think that was like a Freudian slip back then. Because they meant inferior, they just meant lower. Today, I think they are inferior in today's language. But to establish other courts. They knew the nation would grow and they vested Congress the power. So Bob, what's the big deal? Move on. Who cares about that? It's crucial because guess what? If the Congress has created all of the federal courts, go to the next slide, please. One Supreme Court and such inferior courts as the Congress from time to time can ordain and establish. Go to the next slide. Next one. This is our court. This is probably a waste of my time to put this up here. You know who these 3 are. These 2 right here. Right here, I can tell you these 2 right here are probably the only 2, maybe this guy, these 2 faithfully go to the original intent. And here's the interesting thing. Every once in a while, you'll see those two guys come down on different sides. It's rare, but you'll see it. And what that means is that even people that are being faithful sometimes can come to differing opinions on something. But the rest of these people right here, Breyer, Kennedy, Ginsburg, they openly tell us, and in ways that I say this is I study their opinions. I teach their opinions. So I read these opinions that come out. I'm probably one of the few geeks that read the entire Obamacare decision. I read all of it and the dissenting opinions several times. And these people will tell you, when you see an opinion written by these people right here, Justice Kennedy routinely quotes European law. He took an oath to the United States Constitution. Nobody's jumping up and down. Some of us are. Next slide. I'm not trying to make fun of Justice Ginsburg. She had colon cancer at this time. But friends, these people, when they make a decision, there's no override. There's no override. She literally fell asleep that day. Look at Justice Alito. He doesn't know what to do. She's asleep on the bench. This is the respect that they pay to our Constitution when they're doing that. And these people get nominated and confirmed by Republicans sometimes. Next slide, please. So here are the inferior courts. There are 13 United States Circuit Courts of Appeals. There are 94 district courts. I don't want to bore you with details here. I just want you to see that this one is established by the Constitution. These are not. These are established by the Article 1 branch. Why is that important? Because the Article 1 branch has power over those courts. When those courts go rogue, like the Ninth Circuit, they call it the Ninth Circus in California. The Circuit Court of Appeals, they cover regions around the country. When they go rogue and when they do something like that, and our Congress will go, well, we have nothing. There's nothing we can do. And most of us don't know that they can do something, so we can't hold them accountable for it. We can't hold them accountable. That's why it's so crucial for us to understand it. Next slide. Original intent versus the living Constitution. Basically, you've heard the term judicial restraint, judicial activism. Judicial restraint is when the justices restrain themselves to the text of the Constitution, to just what it says. Activism is when they read between the lines. Perfect case, I teach Roe versus Wade. I spent 2 weeks on Roe versus Wade. Not only because I'm pro-life and I want my students to understand the aberration that took place, there are even liberals that will tell you that that case was decided ridiculously. A few of them, not a lot of them. They like the outcome, but they understand that Justice Harry Blackmun in Roe versus Wade, he said that he found the right to destroy an unborn child, to literally chop up an unborn baby. I'm not trying to be graphic just to be shocking, but that's what happens. He says that right is there in the penumbras of the Constitution. Have you ever heard that term, penumbra? I'd never heard it before I read Roe. It's an astronomical term. Why? What is Justice Blackmun doing? He must be a smart guy because he wears a black robe. He must be a distinguished gentleman, and who are you to question him? Justice Blackmun said that penumbra means shadows. He says that he found in the shadows that court. Chief Justice Warren Burger headed that court. He found in the shadows of the Constitution the right to privacy. It was actually found in a case before Roe. It was found in a Connecticut case. But he used it again in Roe, which led him to finding the right in the 9th and the 14th Amendment. I can't go any more on that, but extremely important that we understand there is chasm between original intent and the living Constitution. The living Constitution, logically, even if you don't understand the jurisprudence and the legal stuff behind it, logically, judicial activism means they can make it mean whatever they want it to mean. And if they can mean whatever it wants to mean, why do we need a Constitution? And that's where we are today. Our documents didn't get perverted last night or the night before last. It's been twisted and pulled and contorted and perverted for about 80 to 100 years. They're not reading the Constitution that I read and you read right now. They're reading the same words. The reason they can disobey their oath so easily is because the courts are in collusion with them, and the courts are reading from a document that has been twisted and contorted. They're not reading the same language that's there. Next slide, please. Madison, every word of the Constitution ultimately decides the question between power and liberty. We looked at that one already. Go to the next slide. I'm just going to go through these. These are just some more quotes. If you just go until I say stop, please. Oh, back up. You can't do this without, I can't show you this without showing the other side. So I want you to see what Al Gore says. Look at the folly of this man's words. The Constitution ought to be interpreted as a document that grows. First question is, where does it stop growing? He doesn't answer that for the people that listen to him. I believe the Constitution is a living and breathing document. We have interpreted our founding charter over the years and found deeper meanings, as in the right to chop up a little unborn baby. That's the deeper meaning he's talking about. I'm not just using inflammatory rhetoric. That's what they believe. We have to be able to say that. All right, enough of gold. I can't stand it anymore. Next one. The living Constitution has a, go back one, has a great deal of rhetorical appeal, but it's mindless. The alternative presumably being a dead Constitution. We don't have a dead Constitution. We have a brilliant document designed by brilliant men. They weren't infallible. They were humans just like me and you. They were sinners just like me. They had their flaws. And I teach this stuff. I always got to disarm the opposition because they want to come at you with they were slaveholders and they had wooden teeth, and I don't know what that has to do with it, but you come up with all this stuff. But it's fundamentally at odds with the notion of a fixed rule of law. That's why I put up there, rule of law. The founders understood we needed a law higher than men, a fixed, firm rule of law. That's why it has to be interpreted to its original intent. Next one. Jefferson said, on every question of construction, let us carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debates, instead of trying what meaning may be squeezed out of the text. That's what Harry Blackman did. That's what they do today. A lot of the justices do. Let it conform to the probable one in which it was passed. That's the criteria for federal judges. Next slide. I'm going to go beyond that one. That was Madison talking again about original intent. He had a lot of incredible things to say about that. The Sixth Amendment. The only reason I put this in here, and I don't have any sound, so I'm just going to kind of walk you through it. Maybe you can go look this up. When you get home and you get a chance, you'll find this very interesting. Because I wanted to show you an example of a Supreme Court justice that does this. He does interpret it by original intent. Because a lot of times when I teach this and I speak on it, people will say, you're living in a dream world, Bob. Nobody's going to do that. That's not true. I hate it when people do that. They just make conclusions, or they just make generalized statements, and they haven't taken the time to study it. It really ticks me off. So the Sixth Amendment says that you have the right to be confronted by the witnesses against you. If you're an attorney in here tonight, you already know this well. You have a right to be faced by witnesses that are against you. If you've been accused of a crime, you have a right to face your witnesses. As conservatives and as Republicans, a lot of times, we tend to want the other side to play by the rules, and then we twist them. That's hypocrisy. Justice, I can't play it, but there's a YouTube. It's like a minute 57 seconds. Look up Justice Scalia and the Confrontation Clause. Confrontation Clause. He's been interviewed by none other than Piers Morgan. And Piers Morgan, it brings up a case where a young child had been brutally raped. And the case, the accused in that case, the child got to appear by closed-circuit television. And who among us would want a little child to sit in the room with an animal? But it's in the Constitution. The right's there to protect you. As hard as that may be, if it was my child, it would rip me apart. So Piers Morgan says, because Justice Scalia, when the case got to the Supreme Court, he was in the dissent, and he ruled against using closed-circuit television. And the case ruled in favor of it, but he was in the dissent. And Piers Morgan says, don't you have how can you sleep at night? And Justice Scalia, I can't remember everything he says, but at the end I know exactly what he says. At the very end he says, there it is. It's right in the Constitution. He says, I don't like how things come out. I don't like the way things come out sometimes, but my job is to follow the text. And there it is. And then his final words are, I'm not king. Very, very powerful when you listen to it. Please go listen to it on YouTube. It's powerful because we watch somebody today that thinks they're king. It can be done. There are people like that out there. Now, he's not perfect. There's cases Scalia's ruled on that I go, why did you do that? But he's a lot smarter than I am. Okay. Next slide. Next one. Okay. If I can briefly talk to you about this, the Convention of States Project. Convention of States Project is a project that kicked off in about the mid of 2013, about August. Two guys came together, a guy by the name of Mark Meckler, who was the founder of National Tea Party Patriots in 2009. Those of you who've been involved with the Tea Party, you know that name. The guy's got years and years and years of grassroots experience. And a guy by the name of Michael Ferris, who I know, call him friend. He's the one that asked me if I'd be the state director in South Carolina. He founded Homeschool Legal Defense about 30 years ago. The guy has been in the trenches for parental rights. And one of the few guys to actually argue an Article 5 case before the federal courts. Probably a handful, like 3 or 4 people. He knows what he's talking about. But he's human. He's fallible too. But he's also worked his butt off in the Congress. He worked very closely with Jim DeMint fighting a couple of UN conventions on the rights of the child and one with persons with disability that would just really have stripped parental rights in our country. Without Jim DeMint, he's sorely missing him there. But anyways, this started off. Go to the next slide, please. We can go past that one. We already talked about George Nicholas. The problem, our federal government is out of control and will not relinquish power. What I've just stand up here and described to you, I think we would all agree that the Constitution creates a government of very limited powers. We have a government today of vast powers. They've gobbled up all kinds of territory with little pushback. I mean, we saw Ted Cruz, a month and a half ago, stand up in the well of the Senate for 23, 25, 20-some hours, arguing for what the House of Representatives did in holding the checkbook, which they were perfectly within their constitutional powers. Interesting study. I don't have time. Go and study why the founders gave the largest body the power over the purse, and intended for them to fund and defund laws. People today say, well, the law was passed, they have to fund it. That's absurd. Laws are passed and changed all the time. But anyways, Ted Cruz stands up, speaks on the Constitution, explains that all out, and his colleagues shoot him right in the back. I'll be the first person to tell you we got to keep trying to elect good people to office. I will work tirelessly to do that. We have to elect good people to federal office. But friends, we need another front. It's out of control. They're not going to relinquish power. We've been doing this for a long time, and we're running out of time. Next slide, please. All 3 branches are attacking state sovereignty. You know about the out-of-control spending and debt. Go to the next slide. I showed this in Myrtle Beach. For those of you that weren't there, I call this the 4th branch of the federal government, the federal bureaucracy. 80,000 pages. 80,000 pages in 2013 of regulations added to the Federal Register. Regulations. And we hear that word and we don't realize that they have the power of statutory law when they're passed. The executive orders, those are regulations. All these branches of government, I'm not branches, all these agencies, the Environmental Protection Agency, the DHS, Department of Health and Human Services, 15,000 of those pages were written by faceless bureaucrats. I call them faceless, not to be mean to them, but they're behind closed doors, and you and I have no control over them. We don't know who they are. They're writing law. Because the Congress at one point in our history created an agency and said, here, President, Article 2 branch, there it is, it's yours. So he makes laws through his agency, and we have no recourse over those faceless bureaucrats. We have no recourse. The founders did the first principle of American government, all legislative power in one body, right? So you and I can make them answer for it. That's why the checkbook's in the body that comes up every 2 years, so they can be on a short leash, and you and I can jerk them back. But rarely do we even jerk them back, you know? This is the biggest branch of our government right here. And we have no say when they do that. All kinds of regulations passed. That's what the president means when he says, if the Congress won't act, I'll just go over to my agency. And I'll tell them the right rules and regulations. Obamacare, ACA, whatever we want to call it, the abomination of Obamacare. Thank God for the efforts to nullify it. The abomination that's there of Obamacare. He's changing the law. You all know this. You pay attention to the news, right? He's violating separation of powers when he changes a law. The law has been enacted. As abhorrent as it is to us, he goes about changing it. He can't change it. And they do little to nothing to stop him. So, I mean, what I'm doing is making the case for what you already know. The federal government is completely out of control. And what I would submit is probably where we're going to have differences on this subject right here. It's not on conservatism and constitutionalism. I think we all can agree on that. What I would submit to you is that I think if you honestly look at what's going on, it's far worse than we want to realize. It is out of control. Next slide, please. The cold hard truth. They're never going to relinquish meaningful power, no matter who's elected. Time has come for the states and the citizens to be proactive about taking the power back. Next slide. Bottom up, you can't see, the founders gave us a solution, a convention of states under Article 5. Go to the next slide. Under Article 5, there are two methods to propose amendments to the Constitution. Next slide. Okay, the First Amendment process right here. You're probably familiar with this one, whereby 2/3 of both houses of Congress propose, and the key word is they propose amendments, and when they pass them by 2/3 in both bodies, they are sent to the states, to all 50, 57 if you listen to the president, right?
Yeah.
Yeah.
There's still 50. But they all get sent to the 50 states, and then the Constitution says that 3/4 of those states, or 38, must ratify them. All 27 of our amendments that we have right now have come via this process, and that process has been followed. There's some argument about some of them, and I think you can make a good argument about some of them. But for the vast majority of them, that process has been followed. Matter of fact, some people, I know that we have differences about a constitutional convention, or what some would call a con-con. I would submit to you that right now we are in a perpetual constitutional convention. You realize that the federal government today can propose an amendment anytime they want. They don't need a convention of states to do it. They were going to do something asinine and rogue. They do it right now. You know why they don't do it? Because they can't get it through 38 state legislatures. As messed up as some of our state legislatures are, 27 states today have Republican-held legislatures. And there's probably 5 more that lean conservative, for whatever that means. But I mean, I saw a study the other day, and it wasn't done by the Convention of States. It's just to say, it says America is vastly a conservative nation. It is. Some studies have said liberals make up 20%. They just have the media and the power and the money. And us, we're busy working our jobs, raising our families, and we're not paying attention. But that's another story. But this is the process been used for all 27 amendments. Next slide, please. The amendment process number 2. Amendments proposed, look, it almost looks identical. It is identical with the one exception. It is identical to the first method or mode. I call them modes. It's just my term. Amendments proposed by a convention of states call at the request of 2/3 of the state legislatures. So the Constitution provides that when 2/3 of the legislatures call or apply for a convention, the word in Article 5 is that Congress shall call the convention. Hamilton says they have no other choice in Federalist 85. When ratified by 3/4 of the state legislatures, just like the first process, if I was to flip this slide back, you'd see that's exactly the same. This is in the Constitution. It's never been used, so for the most part, we're ignorant of it. And I don't mean to use the word ignorant as being nasty, we're just unknowing of it. Most of us don't know it's there. It's never been done. Next slide. 34 states must submit applications for the same issue. Congress is required to call the convention. Commissioners debate, propose, and vote upon possible amendments. Proposed amendments are sent to the state for ratifications. If 38 states ratify, the proposed amendment becomes part of the Constitution. It is no different than the first process. The only difference is Washington, D.C. is not involved, except to call the convention and to select the mode of ratification. That ought to appeal to almost any conservative. Again, keeping in mind we are facing a federal government that is out of control. I don't see them fixing anything. Is this a perfect process? I will not stand up here and tell you that. I can't tell you that. What I can tell you is that the founders gave us this. Every one of them that signed the Constitution endorsed this process right here. So, as a constitutionalist, I'm going to embrace all of the Constitution. I'm not going to exclude a part of it. Next slide. Founders knew the federal government might one day become drunk with the abuse of power. The most important check to this power is Article 5. It gives the states the power to call a convention for the purpose of proposing amendments. Key word is proposing. This convention cannot change one word of text in the Constitution. How do you know that, Bob? Because it's the same as the first mode. When the Congress does their 2/3 things, they have to send it to the states. They've never tried to do that because it has to go to the states. The record is clear. That's what they do. Again, we are in a perpetual convention right now. We're in a con-con right now. They can do it anytime they want. Next slide. Now I know I've used up all my time. I cannot go without giving you this history because it's crucial to understand Article 5. If anything I tell you tonight, I want you to learn about George Mason. Because I see the providential hand of God right here in George Mason. I do anyways. The convention ran from May to September of 1787 through the summer of 1787 in Philadelphia. On June 11th, at that point in the process, remember, they are amending the articles. Okay? When people say they came away with a whole new document, I think that's semantics. They amended it. There are provisions from the articles that carry into the Constitution today. It's there. Honest people can debate and disagree on it. You get to June 11th, and they have just placed the process for amending the Constitution into the document. Article 5 is there. And the process has one mode. It involves the national legislature. George Mason, and you can read this, right? Anybody can go look this up. We have the copious notes of James Madison from almost every day of the Federal Convention in 1787. You can go look, there's many websites. You can actually pull the calendar, click a day, and see everything that happened that day. Mason stands up and he says, right now we only have a process whereby the national legislature can effect amendments to the Constitution. He called it the national legislature. Remember that the federal government had not stood up. Nobody was calling it the Congress. Got to understand the history behind that. Today we call it the Congress. Back then he called it the national legislature. He says amendments are going to be necessary. It will be better to provide for them in an easy and regular and constitutional way than to trust to chance and violence. I think that's important to look at. They were giving he was proposing a lawful, orderly process. That appeals to me as a believer. It would be improper to require the consent of the national legislature because they may abuse their power and refuse their consent on that very ground. So he's making the argument there needs to be a way for the people to do this. Right now there's only a way for the national legislature to do it. He says no, and then on September 15th, 2 days before the convention ends, this is where I see God's hand. The convention ends on September 15th. The draft is completed. It is transmitted by horseback to the Continental Congress to look at it. 2 days before, it was a Saturday, I even know the day, September 15th, Mason stands up again, raises his hand. I don't know if he raised his hand, but I like to think he did. And he says, listen, Article 5 right now only has a mode or a way for the national legislature. He says, no amendments of the proper kind will ever be obtained by the people if the government should become oppressive. Think about that. He said that on September 15, 1787. What are we looking at today? Would anybody in here argue, even those that are opposed to what I'm talking about, would anybody argue that we're staring in the face of an oppressive and abusive federal government? I believe they're screaming at us from 226 years ago. This is what we gave you. I think we're late, to be honest with you. If the government should become oppressive, so on that day, it's voted on and the second mode is added to the Constitution just 2 days before the Philadelphia Convention comes to a conclusion. Okay, next slide. All right, our proposal. Let me just go through our grassroots effort for you and then I'll close. Next slide. I told you about Mark Meckler and Michael Ferris, so I won't go to that slide. Next one, please. Our mission is to urge and empower state legislatures to call a convention of states to propose, again, to propose amendments to the Constitution to curb the abuses of the federal government. Next slide. It's a national effort to build a grassroots machine, I call it a machine, that's my word, in at least 40 states. Well, Bob went out 50. We're shooting for 40. Right now we have a grassroots operation operational in 44 states. Different levels in some states. To introduce identical bills for an Article 5, I have the bill in my possession. I handed it to our lead sponsor, Representative Bill Taylor, because one of the ways that we believe a convention can be controlled, we believe that, is that the first thing is that every state introduces an identical article. And I'm going to show you, there are 7 states to date that have introduced this bill in their legislature. Today, Georgia passed it in their House. In their Senate. It's going to their House. They may be the first state to actually transmit an application to the United States Congress. The way that it works is states have to pass a bill calling for an application. The governor has no say in this because the Constitution is controlling in this effort. Article 5 says when the legislatures of 2/3 of the states do this, but it has to be in the House and in the Senate, identical bill. If it's passed in the House, if it's passed in the Senate, it is transmitted to the United States Congress and it goes into a holding pattern until 34 states apply for that convention. But it's key, I want to point out to you that our proposed amendment, if you go to House Bill 4372 or 0833 or 0830, you will see that language right there. And if you go to Georgia's, Florida's, Alabama's, New Mexico, and Alaska, and Virginia, you will see the identical bill. They've been introduced because our grassroots effort has worked with legislators to get them to do that. Next slide, please. The plan to viable political operation in at least 3,000 of the 4,000 state house districts in 40 states. So, in South Carolina, there's 124 legislative districts. We have a state director, myself in South Carolina. I have a colleague in 27 states right now. I told you I have 44 states that have some sort of level of this grassroots effort. 27 of them have a state director. Some of them have this, what is called a legislative liaison. I have one. I have a coalitions director, a friend of mine in the upstate. You'll see him on here in a minute. But next slide. This is the way that it works. The state director, myself, I have 2 other state leaders, but the meat and potatoes of our grassroots efforts, and this is what I wanted to speak to you about tonight, and to ask you to consider helping us in this area, is the district captains. The way that we're going to push this bill through the legislature is to basically build a grassroots army. I'm not going to stop until I do that. If I run out of breath, I'm going to do that. If I'm not successful, that's great. My progeny will know that I left it all on the field for liberty and the republic. I'm not trying to be dramatic to you. I believe that to my core. Otherwise, I wouldn't be burning the candle on both ends right now. I don't get paid for this. I have a full-time job and a family. Next slide. Next slide. Next slide, you want to see my mug. That's the coalition's director, my friend Chad Patterson. Next slide. We have a legislative liaison that works with me with the legislature. Next slide. This is what I want you to show you. District captains, 1 per state house legislative district, to recruit and build an army of 100 volunteers per district. Some districts, that's more politically viable than others. Maybe some will get 50, some will get 150 or 200. But when I reach out one day and I pull the trigger on 124 district captains, and each one of those district captains pull the trigger on 100 volunteers, I'm going to melt the phone lines in Columbia. I'm going to do that one day. I'm already doing some right now, but not near to the level I need to. That you all know that the legislature, I know with S308, I never would have moved it without phone lines and emails. But this is what I'm recruiting right here. I'm looking for district captains, people to come on board and take a legislative district, and all it is to recruit a volunteer. And a volunteer is simply somebody that tells us that they will email or telephone their legislator. We're not asking for money. That's it. That's what a volunteer is. I have many of these district captains already. I'm working towards that 124. I'm going to put one in every district. Their goal for me is to get 75%. I'm going to try to put one in every district. Next slide. Right now there are 38 states with some form of state leadership. That number's already up to 44. That's just kind of a breakdown. Some states I have district. Some states we have district captains. North Carolina right now has district captains but no state leader. Next slide. It is moving forward. Following states have initiated the process. South Carolina, Virginia, Florida, Georgia, Alabama, New Mexico, and Alaska all have active bills, identical bills, as I explained to you. There's a lot more to it than the language I showed you, but that is the core language to call for to apply an application for an Article 5 convention specifically defined to limiting the power and jurisdiction of the federal government. Next slide. These are our bills right here. I added a couple of co-sponsors in the House today. As of today, I just found out, but that's where we are. We're going to try to get it through the House this year. Probably there's some other things that are of matters of importance right now that they're dealing with, and I realize that, and I want those to be successful too. But if not this year, we'll be back again next year. But we're going to try to push it through the House this year. Next slide. And my last slide is this one right here. There's a fear, and I understand it. There's a fear among people of a runaway convention, a convention that would run away. I believe it's based on a misunderstanding of history of the original convention. I think honest people can disagree. I'm glad to talk to you about that. But I think if we were to look on a scale, on a meter, I'm an old aviation guy. I'm an Air Force jet engine mechanic, so I like the meter. The only problem with this meter is this needle right here should be breaking the glass over here, because we are dealing with a Congress that is out of control. I don't think any of you, no matter where you stand on what I just talked to you about, would disagree on that. They are out of control. They will not do what they've been tasked to do. They have to be forced to do that. There's ways to reset the language with good amendments. I give you an example of term limits. Term limits, most polls show that 75%, anywhere from 60 to 75%. The American people vastly want term limits. There's even liberals that want term limits. I'll take it. Vastly want it. You would think with that kind of support, even if we're conservative when we say 60%, you would think that the people in Washington would go, that's what the people want, but that's not how it works. There's no way they're going to cut their own throat. They are never going to do term limits. If we had polls that showed 100%, they wouldn't do it. And even if they did it, the United States Supreme Court has ruled it unconstitutional because 23 states have done it. The only way to affect term limits, I'm convinced if we were to get a convention of states, maybe you call me a dreamer, I don't know, that's okay. I think that that's one of the things, that one of the first amendments that have been thrown down the table. Listen, are there not liberal delegates that would show up at a convention? Of course. I don't think there's enough of them. And I know there's rhinos in our state house legislatures. That's why we want to build a machine to control that the best way that we can. So I'm asking for your help for that army. The only way to do it is with that army. No matter all the things that we try to do, that's what it takes. But I'm convinced that that a convention could pump out a proposed amendment like that to the states, and we get it in short order. We might get it in 6 months. I don't know. Maybe that's me dreaming. I don't know. But I think there are much more important ones. Levin, some of you read Levin's book, The Liberty Amendments. He's got some proposals in there. I don't agree with all of them. He's got some good ideas. They're just ideas, but they are good things to think about. A 3/5 override of a Supreme Court decision, that would be 30 states. 30 states would be a lot. That would be consensus. The founders intended for there to be great consensus. I know there's a 10th Amendment. I'm well aware of it. I've been teaching it for 15 years. What I'm telling you is the 10th Amendment has been twisted and contorted and perverted so much they're not reading the 10th Amendment that you and I read. Well, Bob, what makes you think if they're not following now, why on earth would they follow anything we change? It sounds like a good question. On the surface, it is a good question. I think it betrays a misunderstanding of what's happening. They're disobeying their oath today, yes. The deeper question is, how are they able to do that? They're able to do that because the courts are in collusion and they're not reading that Constitution the way you and I read it. At least those of us that search for original intent. Clear language, they would have to follow it. Oh, Bob, do you believe, why would they have to follow it? They don't follow it now. All of the modern amendments are followed to the T. The presidential term limits are followed 100% of the time. Well, we hear rumblings from the nut jobs that they're going to try to break it. And I don't put it past this guy to try to do it. But 100% today it's being followed. Women's suffrage, or any of you women here can't vote? That's a modern amendment. It's being followed. The Bill of Rights being eviscerated. It's hundreds of years old. You and I think it's sacred. I want to protect it. I'm incensed at the NSA and what they do. But what I'm telling you, the reality is they're not reading it. Clarified, clear language and a reset of that 10th Amendment by clear provisions, maybe a state override. Nullification is something that we're trying to do right now. It's a symptom. What we're trying to do is go to the disease of the beast, to put a stake in the heart of the beast. We'll be nullifying until the cows come home. And I'm not playing that down. We need to do that. What I'm telling you is there's thousands of laws we need to nullify. We don't have time to do that. We got to kill that beast. And the way to do that is, this is the way the founders gave us. I'm standing on the shoulders of the founders. I'm not trying to be melodramatic. Come with us and do that. Thanks for your time. I know I went over. Thank you, Linda, for letting me speak tonight.